Welcome to this video. Today we talk about the jurisdiction and rules applicable to bank guarantees, the legal framework that governs the guarantees, international rules like URDG 758, ISP 98, etc., as well as the local laws. Sometimes there could be conflicts or differences between these frameworks and how they are to be resolved also we will touch upon. Most of the demand guarantees or the bank guarantees are subject to uniform rules for demand guarantees URDG. So the governing rules are URDG. It is the globally recognized framework published by International Chamber of Commerce Paris that governs demand guarantees. It provides standardized rules for issuance process, claims process, amendments and termination. So they provide clarity and standardization in interpretation and execution of the guarantee. They uphold the independence principle. They ensure enforceability regardless of the underlying contract. URDG also specifies detailed procedures for compliant demands, including the minimal documentation and time frame requirements. So what it offers is clarity and standardization, upholds the independence principle, lays down the claim process and defines the termination. The conditions under which a guarantee will be considered as terminated or expired. The applications. URDG is widely used in international trade and project finances, mostly in independent guarantees or bank guarantees, and the adoption of URDG reduces ambiguity, so it fosters trust. A multinational corporation that secures a performance guarantee from their bank governed by URDG 758 for a construction product, for example, with an ancient government agency. When the contractor defaults, the beneficiary can submit a claim that will be compliant as per URDG, because what are the requirement for a claim, how a guarantee will be looked upon is already defined in URDG. So there is uniformity and easy understanding and less complexity. So the issuing bank pays without requiring proof of default due to the independence principle. Let us look at ISP 98. ISP 98 is a set of rules published by Institute of International Banking Law and Practice IIBLP, and they govern mostly standby LCs, SBLCs. Sometimes they are applicable to guarantees. They are often secondary payment mechanisms. In case of a default only, you will make a claim. The demand based payment is evidenced in URDG and ISP 98, that is, payment upon presentation of compliant documents, not evidence of default. There is a flexibility because there are provisions for standbys, including rules for amendments, when and how it will expire or extinguish itself, and how to handle the discrepancies in documents. There is a global recognition to these rules, ISP 98 and URDG. ISP is commonly used for standbys in cross-border transactions when one of the region is associated with United States, because ISP 98 was given birth to in United States. If the exporter fails to deliver, importer can make a compliant demand under the standby LC. So they are used for beneficiaries who are more conversant with ISP 98. They are used in situations where flexibility and definition of the various situations like amendment or discrepancy in claim or expiration is required, and they provide uniformity. Now there are some guarantees which are not subject to URDG or ISP but is subject to the local laws. Local law means the legal framework imposed by individual countries or jurisdictions that regulate the guarantee in their own country. So there are guarantees which have a jurisdiction specific requirement incorporated into them, and so it could sometimes help avoid conflicts and sometimes create potential conflicts with international rules. The characteristic of guarantees subject to local law is that some countries impose local law should be mandatory. Some countries mandate registration is required. Some countries have local law that overrides other frameworks like URDG. For example, most of the guarantees in India are subject to Reserve Bank of India guidelines, which is not necessarily 100% in sync with URDG or ISP, but adapted to the local requirements of India. In Middle East, there are guarantees which are Sharia compliant, not URDG or ISP 98, but Sharia compliant guarantees that may be required for certain scenarios. The conflict. Precedence of local law is well established. Local laws take precedence over international rules unless explicitly excluded in the guarantee text. This is because guarantee is subject to the jurisdiction where they are issued. The laws of the office of the issuer and the courts of the place where the office of the issuer stands is what will decide how a guarantee will have to be subjected to legal review. Why local laws prevail? Guarantees are legally binding instruments governed by the laws of the country where it has to be enforced. Regulatory bodies in certain country also impose a mandatory requirement that override the international standards. So to avoid conflict, what should we be doing? Mitigate by way of legal advice, specify by bringing in whatever rules or equivalents, and then understand that the local law will always prevail in a particular jurisdiction or a legal framework. Practical implications of choosing a governing framework. What are the practical implications? Avoiding ambiguity, applying a specific rule is all necessary, and without a legal advice, having a local law guarantee without knowing the local law could create some confusion at a later stage. International transactions, if you have a cross-border trade or a contract, then it is advised to prefer international framework like URDG or ISP. If the transactions are purely domestic, the goods, the services, the buyer, the seller, then everybody is domestic, then local law would be more than sufficient, because every party is mostly familiar with the local legal requirements. Sometimes you have an hybrid approach where you combine the international rules with the local laws. For example, guarantee is governed by URDG but complies with mandatory provisions of, for example, Indian law, Qatar law, Oman law. If you need enforceability across borders, then there is a need to recognize the international rules. Many countries have recognized URDG 758 and ISP 98. So, there will be limited challenge in enforcement. But there are jurisdictions which have weak legal systems or limited recognition, and then enforcing a guarantee might be challenging. So the party should consider whether you need to also include an arbitration clause or a jurisdiction specific rule. So parties should prefer international framework. Local law may suffice only if it is domestic transaction. Otherwise, you may go in for an hybrid approach. But to prevent enforceability issues on states which have a weak legal system or a non-recognition of URDG, you should have alternative mechanisms. Alternative mechanism could include arbitration to mitigate the potential risk that may come up. Now, one example is a US based importer, for example, enters into a contract with an European supplier, say for delivery of certain goods. Then the supplier requests for a guarantee governed by URDG. But US likes what? ISP 98. Then what do? US is familiar with ISP 98. URDG is more popular in Europe. What do? Both parties agrees to use ISP 98 but include a clause specifying the guarantee will align with URDG, such as independence and demand based payment. The guarantee is issued in US dollar and subject to New York law to ensure enforceability in US courts. So the hybrid approach satisfies both the parties' preferences. It also ensures compliance with international standards. So, understanding the interplay between the international rules, URDG, ISP with the local law is very essential to ensure the guarantee is enforceable. It is effective. So, While drafting a guarantee, one has to specify the applicable rule, one has to seek professional advice, and then one has to avoid ambiguity so as to easily resolve conflicts, if any, in the future. The frameworks provide clarity, standardization, and bring about the independence of the transaction. So, keeping in mind the jurisdiction specific framework, one has to adopt the legal rules and the codes that apply to a specific guarantee. Thanks for watching this video. It is very important to ensure the rules of the guarantees are specified to avoid ambiguity. The local law which applies or the codes that govern the transaction is well established within the guarantee text, and an understanding of the framework is there for all the parties concerned.